Okay, good afternoon, everybody. Thank you so much for coming out this afternoon. For those of you who don't know me, my name is Yolanda Jackson. I'm the Interim Executive Director of both the Bar Association of San Francisco and the Justice and Diversity Center. Welcome to the Future of the Legal Profession, a thought-provoking and information-filled discussion with our very own Ralph Baxter. Why are we having this discussion at this time? Well, since the recession, there has been a big debate swirling about whether falling law school enrollment and changes in how clients do business, technology being added on to everything that we do, and the trends around how the legal profession is transforming has spurred a lot of discussion around what does that all mean for how all of you provide services, what areas you should be providing services in, what's a commodity service, what's a complicated service, and so Ralph is going to take us through that discussion and what that all looks like and what that all means for us and the Bar Association. Why are you all here and why were you invited? Well, we consider you as leaders of the Bar Association of San Francisco and of JDC. Very strong and committed leaders. And you've shown a great deal of commitment to both organizations over the years, and we want your brilliant minds to be a part of this discussion around how you all will provide legal services in the profession and how we as an association will operate going forward. So that's why you're here. I now have the privilege of introducing one of the most forward-thinking people I know and have met since I've been here at the bar. So please allow me to introduce you to Stephanie Scaff, who is the chair of the Intellectual Property Litigation Department at the Farella, Braun and Martel firm. She represents companies in complex litigation involving intellectual property, technology, privacy, and licensing issues. And we also have the great honor of calling her our president this year. So please join me in welcoming Stephanie.
I just want to echo Yolanda's thanks to all of you for giving us some of your time this afternoon. I was speaking for a few seconds with Ralph before we started, and I know he's interested in an interactive discussion, which is what I'd like to see here today as well. One of the things I've been struck by the most in this last year as president of the Bar Association and of JDC is how much the practice of law has changed. And I've been practicing law since the beginning of my career here in San Francisco, and I know that I've seen firms that I knew who are no longer here in our landscape, new firms that I've entered. I've seen shifts from the number of lawyers who are working at firms and what the firms look like internally, lateral movement between firms, and also increasing numbers of folks working outside of the law firm environment. So there's a lot of changes going on, and all of those changes impact us as a bar association, how we serve our members, how we reach our members, and most importantly, how we engage them in places that they care about and on issues that they care about with the time they have available. So that's the discussion we want to have today. What does our environment look like? What are the challenges for us? What are the exciting new opportunities for us to serve the changing population of our lawyers here in San Francisco? And we're really, really pleased to have a real leader in thinking and innovating in this area with us today. All of you are probably familiar with Ralph Baxter. He served as the chairman and chief executive officer of ORIC from 1990 through March of 2013. And under his leadership, ORIC really expanded from what I early knew when I was coming out of law school as a local San Francisco firm to really a global law firm environment. In 2013, the American Lawyer named Mr. Baxter one of the top 50 big law innovators of the last 50 years. And innovator is the right word. He took a lot of concepts out of the box. He took law firms and looked at them differently and said, what services should we be providing as lawyers? How can we do this differently? One of the publications talked about him upending traditional career models, rejiggering payment structures, transforming the business of law. Those are the types of words that people use to talk about the innovations that Mr. Baxter had made in the law firm environment. He's a frequent speaker on business leadership and the evolution of the legal profession. He founded the Law Firm Leaders Forum, which is a group of law firm leaders that gather annually to talk about changes in the law firm environment. So I can't imagine really anyone who is better qualified to come talk to us today and engage us on a discussion about innovation, not only in our community as lawyers, but also in the work that we do as a bar association. So if you will join me, please, and welcome Ralph Baxter today.
Well, I'll try to live up to that introduction. It will be very challenging to do that. I'll also try to live up to the topic, the future of the legal profession. That's a reasonably broad topic. And I'm going to talk today about my perspective, and I'll tell you in a moment where my perspective comes from. But I don't think I'll capture the entire future of the legal profession. Let me start by sharing with you what I do today. I was at Orrick for 40 years, which proves I may not be that innovative because I don't have enough imagination to change jobs. But I was at Orrick for 40 years. In fact, 15 of those years we spent in this building. John Streeter was saying to me earlier that the first time he came to this building, he and I rode up the elevator together as we were looking at our new space. But I'm done with being a leader of a big law firm. I'm technically chairman emeritus of Orrick, which means I don't do anything. And I've been spending the better part of the last year and a half trying to learn about other facets of what's going on in the delivery of legal service. And I'm hoping that I can continue to be a catalyst for change in the evolution of the way legal service is delivered to all of the people who need it. And that may or may not be. But what has happened is I've learned a lot. I've met a lot of different people who see the world differently than big law sees it. I really feel like I understand big law better than I did before from that perspective. Now, my perspective has also been assisted because I moved. I moved from San Francisco to Wheeling, West Virginia. And the perspective from there on almost everything is pretty different from San Francisco, but including issues concerning the delivery of legal service in small-town America, which has been pretty interesting. Now, I'm going to talk today principally having said what I just said, principally, though, from a perspective of my 40 years in big law and my understanding of how legal service is delivered by corporate law firms that are focused on corporate clients and doing business law. But I want to say at the beginning, I think the biggest challenge that we face in the United States is meeting the needs of the citizens for legal service. And most of the things I'll talk about today apply to that setting as well. But we don't have access to justice, and we don't have the meaningful equality of opportunity that we want as a country if people can't access the lawyers they need to do the business of life in the way that the 21st century requires. And law has become, as I'll talk about, far more important for everyone, but it includes individuals. And I won't talk too much about that today, but my personal belief is that is at least as important, probably more important than the business issues that we will talk about. So let me start with this. I think that this is a great time to be a lawyer. I think it's a great time to be involved in the delivery of legal service in whatever capacity you do. And I mean that really unqualifiedly. As I'll come to, there are great challenges, but this is a great time. Law has never been more important, ever. You will hear consultants say, well, the demand for legal services is flat at best, or it's declining. Has anyone heard that expressed before, that the demand for law is, right? And you hear that, especially in the context of the Am Law 200. And as I'll come to, the demand for legal service from the Am Law 200 is flat, and it is declining. Not only is it declining in the number of engagements, it's declining in how much the market's paying for it. But the overall demand for legal service is growing. Law is more critical to every business decision that almost every business in the world makes than it's ever been. Data is more complex and growing exponentially, making everything more complicated. Regulations are growing. And so the law for every citizen and for every business is more important than ever before, and there is more demand. What the big law firms are feeling is that the demand is being met by others than the traditional largest, most successful law firms, and we'll talk about that. So it's a great time to be a lawyer in that way, and it's a great time to be a lawyer or otherwise in the delivery of legal service, because it's a time of change. Things are possible today that weren't possible before, and the elements of law practice that drew us, those of us who are lawyers, drew us to the law, are going to come back. We're going to do more of that than we were doing for a long time, less doing of the mundane, less doing of the routine, and more doing of the things that call upon our judgment and special talents as human beings. So I think it's a great time to be engaged in the delivery of legal service. It's also a risky time if you are an incumbent. If you were successful right up through the Great Recession, this is a challenging time. Actually, no matter what happened to you in 2008, 2009, this is a challenging time because change is going to be required. For the reasons I'll share with you, in my opinion, change is going to be required in how law firms operate, how individual lawyers operate. We've got to be really better, really faster, and really cheaper than we are. And not everybody is going to be able to adapt in that way. One of the things that is confounding to me is that how slowly the market is moving, how slowly the changes are coming. I expected them to come faster and come in a even more predictable way. They're not. But as we'll now talk about for the next half an hour or so, I think the changes are coming for sure. So I'm going to talk first about what I think the drivers of change are, and then I'll share with you my outlook about what the world's going to look like moving forward. So let me start with the drivers of change. There is no question that the principal driver, the unmoved mover of change, is the corporate client. The corporate client that is confronted with the need to do more for less is now requiring lawyers to deliver more for less. And this is something that has been talked about as long as, looking around the room, many of us have been lawyers, certainly as long as I have been a lawyer. That the clients were going to demand more, the clients had the power, they were going to take charge, and they were going to demand that things would be different. They would kill the billable hour, and things were going to be different. And that really never happened. But this time is different. It was accelerated by the Great Recession, but mainly it's different because the participants in the delivery of legal service are different, because the prospect of delivering legal service better, faster, and cheaper is more real, and the dynamics of capitalism and technology are going to work together to lead us to a very different and I think much better day. But it's driven by the clients. Precisely because law is more important than it's ever been, we are now a bigger part of the spend of these corporate clients. And so when they all get together with the C-levels for their periodic meetings, and every other head of every other function in the corporation is reporting on how he or she has reduced spending, the general counsel no longer can say, well, of course, our spending's going up. And they're not going to do that anymore. So we had the meeting, the 19th Annual Law Firm Leaders Forum just happened last week in New York. And in a panel that was really to sort of an update on what we're talking about here today, I asked the leader of one of the largest financial institutions in the world and the leader of the law department to talk to the audience about his outlook on this subject of more for less. Because I'd heard him talk about it before. I knew it would be good, and it was. And he told them how much they spent, and it was astonishing how much they spent per year on lawyers, especially on litigation, and then said in unqualified terms, we're going to spend less. We spent less this last year than we did the year before, and we're going to spend less next year than we do this year. And that's not because we need less. It's just because we're going to pay less. And that is happening. The data shows it. The American lawyer data shows that the amount of money being spent on law firms is going down. And certainly it is so that the amount being spent per unit of value is going down. So if you could isolate a unit of value that a law firm delivers to a client, a case tried, a deposition taken, a merger completed, you can see that the amount of money paid for that is going down. But you certainly see it in the revenues of firms year to year, and you see it in the realization year to year. The amount of the stated fee, hours times rates equals X, and the law firms are getting a smaller and smaller percentage of X. So it really is happening. The best article I have seen on this just was published in the American Lawyer magazine, written by Eric Press, who for a long time was the editor-in-chief of American Lawyer. And he drew on some data that AmLaw and American Lawyer Media had put together about the course of big law. And there's some really interesting findings in his article, and I commend that to you. But one of them is that the market is paying less. All right, so that's the unmoved mover, I think, is the clients. The client pressure, but for that, I don't know how much of the rest of it would happen. But because of that, it's going to affect law, and it will create mechanisms to deliver legal service that will affect everybody. So it won't only affect the big clients who are demanding more. It will affect everybody, and it will lower the cost of delivering legal service for everybody, including the citizen. So number one is that. Number two, there's room for improvement. That's the constructive way of telling somebody they need to do better. There's room for improvement. Well, law firms have gigantic room for improvement in becoming economically efficient. We are manifestly inefficient. And when I started law practice, no one ever suggested to me, and maybe probably not even when John started law practice, one of the most important things you need to do is limit the amount of money we spend delivering service to a client. It's not how law firms think. I mean, at our best, we are professionals. And this is not about turning a profit. It's not about having costs be as efficient as they can be and watching carefully the delta between revenues and expenses. It's about being great lawyers. And that's a good thing. It's a very good thing about us. In fact, one of the problems we face today is law firms, the big law firms, have become way bigger than anybody ever had in mind, which requires decision-making and thinking of all kinds that we're really not very well prepared for. But we're certainly not prepared for being efficient like a startup. I'm going to talk a lot about startups in a moment, but they are efficient from day one, because otherwise their investors will disappear, or they will disappear. And that's not the mindset that law firms have. And so there's literally, and not because we're bad people, not because people are padding hours or trying to be more expensive than we need to be. We just don't have the ethic to start with to be as efficient as we can be. And that there's a vulnerability of that is important in this whole thesis of why things are going to change. If we were operating our law firms the way Cisco operates Cisco, and the way HP operates HP, then we'd be less vulnerable. But it's just patent that we could be more efficient. Now, there are two other elements of causation that are really important. One is the prospect of disaggregating complicated legal engagements into smaller parts. And everyone knows you can do that. But that really is going to matter here because the clients know it too, and they're going to expect us to do it. And if we don't do it, as lawyers, no matter what size firm we are in, the clients will do it for us. And there's a whole industry of companies that are being created who will volunteer to do it for the clients. And so that enables this idea of disaggregating complicated engagements into smaller pieces, enables all sorts of changes to happen to make law more efficient. At Orrick, for example, we have a center in Wheeling, West Virginia, where I now live, and we have now 350 people there on any given day. 150 of them are lawyers doing disaggregated work. We don't practice law in West Virginia unless one of our clients has a case in West Virginia, but we don't. One of the deals we made with West Virginia is we would never compete for legal practice in the state of West Virginia. But almost every big case, almost every big transaction that we do has lawyers in West Virginia working on it. And so that just because you can do it that way. The other issue is commodity practice. And commodity practice is kind of a bad word in an AmLaw 200 firm. We don't want it. We do the good stuff. We only do the really important stuff. We don't do that commodity stuff. Well, we do. Every law firm in the world does some commodity work. Everybody. and certainly, and it's a significant portion of the work that most law firms do. And when it is commodity, that means it has become relatively routine. We have done it before. We can do it in a way that is predictable. And as soon as that is so, you can start doing it with technology. You can start doing it with people who are not graduates of the Harvard or the Stanford, the Harvard or the Stanford Law Review or any other law review. And that's an important part of this, of the change as well. Now, I have lost my talk here. I'm experimenting today for the first time using. Yeah, I'm innovating. But I'm innovating right in front of you, and it didn't go well. There we go. I'm innovating. And now I'm adapting to challenge in the middle of innovating. So those elements of the story come right from the law firms ourselves, but then come the rest of the stuff. So technology. Eric Schmidt wrote in one of his recent books, science fiction is becoming reality. And at Google, it is, because they've got driverless cars and glasses and all that stuff that they've got. But in law it is too. We'll talk about some of the examples in a moment. But the technology more and more can behave in a way that looks like it's thinking. Right? And all of us have experienced this to some extent. But it's more now than just sorting information. It is learning. The programming, the application of statistics now enables the technology to learn. And as the technology learns, the technology can do more and more. It doesn't just do the fundamental routine information exchange that it did in the early days. It can now do parts of the work. I'll talk about Watson in a moment. How many of you have heard about Watson going to law school? We all know Watson, right? What's the most famous thing Watson did? Won Jeopardy. And when you meet people from Watson, when they're telling you about law, they start with Jeopardy. And that was the moment they proved to the world that it could think. So Watson went to medical school, and Watson has now gone to law school. And Watson, IBM describes Watson as an inexhaustible fourth-year associate. And so that's at one end of the spectrum. So technology comes into the picture because it enables things to be done really differently. And then there are the new entrants. So there are countless, really, new businesses that are being formed every year to participate in the industry of the delivery of legal service. They're formed not in this country, not to practice law. They're formed to deliver some of the service that is embedded in the delivery of legal service. Now, this is a really important concept. Let me just talk for a moment about it now. So it has always been so that in the practice of law, there are some essential tasks that themselves are not the practice of law. That's why we have paralegals. That's why there is a paralegal career track. That's not the practice of law, but it certainly is essential to what we're doing. And every clerical person is doing work that is essential to the delivery of legal service. But as law has become more and more complicated and more connected to data and complicated issues of fact, there are more and more ways that elements of legal service can be disaggregated and done by people who are not licensed to practice of law, because that work is not the practice of law. And that is what has enabled in the United States the creation of these new companies. In England, they can be created because it's all right for a company to both practice law and do other things. It's okay for a company to be owned by investors and practice law and do other businesses at the same time. In the United States, you can't have public investment in law firms, and that we have much more limited options for law firms, but we don't have limited options for companies that are not law firms to deliver elements of what formerly was thought of as the province of law firms. The monopoly of lawyers and law firms in the delivery of legal service is breaking down. In England, it was just abolished. But in our country, it's breaking down because the market is on to the idea we can disaggregate, we can routinize commodity work, and because the bar associations progressively are being more tolerant to permit these new companies that are not law firms to engage in the delivery of legal service. And that is going to accelerate dramatically the change that is underway. Last year, there was $500 million invested in these new companies, and which is not very much in the world of venture capital, but it's a lot in law, and it's created a lot of really interesting companies, and we're really at the beginning of that. And then finally, there will be competition. Competition will drive this change. Some firms will get onto this and accelerate the pace of change. The company that I think, the firm that is leading the country in innovating and embracing what is possible with technology and new process engineering, is Seyfarth Shaw. Seyfarth really has, for 10 years now, embraced what is possible as part of their ethic of running their firm. At the Law Firm Leaders Forum last week in New York, we had Stephen Poore, who's the chairman of their firm, tell the story of how they started and how hard it was to revamp the processes at Seyfarth. But they have done a remarkable job, and other firms have too. Oryx certainly has done our share, our center in West Virginia, which now maybe a dozen other law firms have copied that idea, which is really itself a small idea. It reduces the cost by millions, but that's in the context of hundreds of millions of cost. But it sends a signal to the law firm that we're going to do things differently. And I think that will accelerate. It will accelerate because some subset of firms will make changes. They will either be the firms that are in trouble, that really are worried about surviving given their economic performance, or it will be the ones like Seyfarth that see a better future. And Seyfarth was aided because its best-known practice, labor and employment law, was under pressure in the market before all of these other changes. So it had a financial reason to make some of the changes, but it was ahead of the game. Somewhere along in here, as part of what will be an evolution, more firms will innovate, and they will accelerate the change beyond these new entrants. The final factor to me that is going to change this is the changing outlook of the law students and the young lawyers. When I was in law school, the only thing I wanted to do was join a big law firm, one that might even be 100 lawyers. I didn't. I joined one that was 65 lawyers, but join a law firm, make partner, and practice law. That is not how the modern law student sees it. This is not a surprise, right? Does anyone disagree with me on that? All right, so more and more, the people who do want or are willing to join a big law firm, I mean, there always will be some who are well suited for big law or for private practice in the pressure cooker that big law is. But more and more people join it in order to pay off their student loans or to get the experience they need to go on to the career they want to have. And that reason that is important is that it will change both the people that are in the practice of law, but it will fuel the new companies. People who are really smart, really intense, who are educated in the law will be available to work in these startups. I visited recently to one of these innovative companies and met the people who were leading it. And they were all former partners in highly respected firms. And so I asked each one why they changed, and the answer was they didn't want to be partners in highly respected firms. They didn't want to do all the things that being a partner in a major law firm requires. And these were people who were not technically young. They were very experienced, but they had made the change. And I think that's going to drive a lot of this change. Now let me stop there and see if there are any questions about what I have said or pushback on what I've said so far. it is predominantly about process. It's more than that. It's not fair. One of the major things they do is map the process to deliver legal service. And this is one of the advantages that the startups have. So they think about, using Six Sigma methodology, if you're going to try a employment class action, what are the steps that you really ought to take, and in what sequence and by what people, in order to do that successfully and efficiently? And so they have mapped all the different kinds of things they do. Over the years, they've mapped everything. And so there is a Seyfarth way to do each of the kinds of things that they do. And like the technology, they learn by experience. So each time they do one, that experience informs the mapping. And so that's really the core of what they do. And it takes commitment. I've tried to do this in a law firm myself. It takes real commitment and real skills to literally map the process of doing a complicated legal engagement. In a recent panel, I heard a woman who'd been chosen because her firm was so outstanding at project management. So she was asked to talk to the audience about project management. She told this elaborate story of how they'd done all these things to develop the skills of project management. And then she proudly said, and many of our partners are doing it. Many, really many. Not most, but many. And she was being honest. She didn't realize she was being amusing, but she was being honest that they'd done all this, but most people weren't doing it. The real trick in changing big law is getting people to do it. I can tell you from experience, it's easy to get people to nod when you explain we're going to do something new, different, and spiffy. But then a year later or 2 years later, when you test for how real the adoption is, you see how hard the work is. You know, one of the realities of big law is that, and really one of the realities of all successful law firms is that they make a lot of money. All successful law firms make a lot of money. More money than most of the people in them ever intended to make, well, at least the ones over 40 intended to make. And more money than they actually need to make in order to be successful. And they certainly charge more than they need to charge because they spend more than they need to spend, because we're not as efficient as we could be. Every law firm could remain as profitable as it is and charge clients significantly less by simply being more economically efficient. By driving down their costs, they could maintain the same level of profitability, lower fees to the clients, same profits, but lower costs. But it's hard work to do that. But because law firms are making a lot of money, the average lawyer does not make a lot of money. We all know that. But lawyers in successful law firms make a lot of money. But because they're making a lot of money, they don't have an imperative, a selfish economic imperative to change. And that's one of the things that slows up the progress of change. But at Seyfarth, they had vision. John.
I always hate this when people do it to me, but I'm going to try it with you because I know you.
Right.
I'm going to ask you two questions instead of just one.
Okay.
The first has to do with the first driver you started with, and that is that there's this inexorable process of costs being driven down that's coming from our corporate clients. And, you know, we all nod and we see that and the pressure on fees. But I've always thought that this work is going somewhere. The pressure on fees is there because corporate clients have the alternative to have that work done elsewhere. And one of the places that's going is inside, and their headcounts are growing, and they're doing things that we have traditionally done. So it's not so much that the work isn't there anymore, you know, just as you said.
Right.
There's more demand than ever.
Right.
But it's being done in a different form, and I think that's to a larger extent than before. That's inside in these corporate legal.
Right.
The second thing that comes to mind, and I'll ask you about this as well, to comment on, is and isolating things that are routine and getting more efficient by extracting them out, the Richard Susskind idea is right.
Mhm.
We all recognize it in many ways. One of the things that overlooks, I think, is that there is this essential value to what we do with our judgment. It's our independent judgment as lawyers. So to the degree that we are looked upon as delivering widgets, and that those widgets can go anywhere, they can go to India, they can go in-house, they can go wherever they're cheaper. Who is it that is left to deliver what is essential about what we do? And that is not only a scary notion. I think it's a dangerous notion. And I think we as we all kind of get on board with this idea that, hey, let's just kind of deliver what we do in different forms. Let's remember who we are.
Right. That's right. And so who is left? John, because you all could hear John, right? So John says, who's left when we've farmed out all this work? And who's left to exercise the judgment and do those things that really at the end of the day you do need to be not just a lawyer, but a really good lawyer to do? And the answer to the question who is left is a very happy, highly rewarded lawyer who is doing what he or she went to law school to do. I mean, I really think that if this played out the way that I think it should play out, and I believe it will, we're all going to be better off, including the individual lawyer who studied hard, top of the class. Just imagine your example, and then finds herself mired in e-discovery and all this stuff that nobody wants to do. And if you could take that away, I wrote a blog on this last week. If you take the mind-numbing stuff out, and then that's what's left for the lawyers to do. I think that's the answer, and it has to be the answer. This will not proceed to a place in which the machines purport to exercise judgment, because they can't. They can do things that look like they're learning and look like intelligence, but they're not. They only can do what you tell them to do. And so there are moments, and this is the limit on Watson. So there are moments where the machines can't do it, and all the technology people will tell you this. The technology people will tell you it all works best when you combine the technology and a human being. And not only will they tell you that, they've tested it. So the technology can do great, the humans can do great, together they do the best. I'm not afraid of that moment. First of all, what I've learned over the last 2 years is the thing's proceeding slowly enough. I'm not worried about anything. But I think the way it'll shake out is that we all will win, because the careers of the lawyers will be better careers, because more of what we do will be the kind of thing that tests our judgment and exercises our judgment. And the stuff that is boring, boring, will be done by machines or be done by people in settings where that work is appealing in context. Right. That's exactly what it's like. And that is not the practice of law. Right? But there are tax questions you do need a lawyer for. And they're the ones, the whole tax practice, I've concluded at some point, is about questions to which there is no settled answer. If there's a settled answer, TurboTax can do it. Right? When there's not a settled answer, that's when you need a lawyer who understands how it all works and can help you make the judgment you need to make, because you're going to be taking a chance because there is no settled answer. Yes?
I just thought that over the last 20 years or so that there's a parallel between what's happening in the healthcare industry and what's happening in the legal industry. If you look at acute care hospitals, overnight stays are not what they used to be. They do not admit patients unless they have very high acuity, really need that level of service. And anything else gets sent home, right? And it's because of the cost pressure. And I think this is true in practice as well, and it kind of goes to Yolanda's comment about There's so much information available to a client now. They can find answers readily on the internet for free. Basically, the internet
Yeah.
service provider monthly fee is providing them with all of this information that 20 years ago people didn't have.
Right.
So they would call up lawyers for advice on things that they just needed to find the answer. They needed to find what statute, what reg, what rule is it that I need to follow here, and I need a little guidance on that. A lot of that can be done by your grandmother, or by your mom, right? So it's changed a lot. And so what I think firms are doing more and more of, it seems to me, is litigation, is where there's a principal dispute that neither party is willing to settle. And that's the bread and butter of the firms that are still going, full steam.
Yeah.
And then on the in-house side, I've been in-house, been in firms, been partner, law firm, all that. In-house, I was in a group where we were trying to set up basically a legal call center, where you would have case assignment, a case number, not the court case number, but the internal case number. If there's a software licensing agreement that needs to be turned around within X number of days, and there was a tickler and a way to keep track of who had it, who was working on it, when it was going to get done. And I have to tell you, the lawyers did not like that. They didn't like being the ITIS help.
Yeah, right.
And so there was a lot of pushback. Now that may change too. As new lawyers come into practice, they'll be used to that. Managed care, same thing. Senior doctors say, I'm out of here. If I'm not going to Kaiser and I have to go to paperwork, I'm out of here. I'm going to retire early. New people coming in, they don't know any better. That's the way it's always been. It's like somebody coming into practice now doing 2,100 billable hours or 19 or whatever the number is stated in the interview versus reality. It's a lot different than 1,700 back in the days at Thielen. It was genteel and simple. Anyway, that's enough.
No, but you're right. You're right about all that. So the medical, what's happened in medicine to law, there's a lot of learning to be done there, good and bad, right? Things not to do and things to do. But one of the key things I'll come to about the world of tomorrow, when you go into the world of medicine, and the first 10 people you encounter, how many of them are doctors? Right? And how many of them introduce themselves and say, hello, my name is Lois, I'm a non-doctor? The reference isn't doctor, non-doctor. They're all medical professionals. All right? They're all collaborating. They all have jobs. And they sought those jobs. And not everybody's happy at anything, but there's job satisfaction in every job. And some of those jobs are doctor. In law, we don't have that. The ratio of non-lawyers to lawyers is very low, and it won't be in the future because it shouldn't be. There's all this work to do that does not require you to have gone to law school, does not require you to have taken that stupid bar examination, which didn't test you to be a lawyer to begin with anyway, but it doesn't require that. It just requires you to know what you know and have good judgment, good people skills, whatever it takes to do the work. And I think that's a really important analogy to medicine. About the doctors that were in the lawyers that were in the call center, I think all of this ends up being about managing people's expectations and creating careers that are rewarding careers. And so there are some people who would have loved that job that those guys didn't like. You just didn't happen to have them in it, right? And at times of change, it's harder. So we created at Oric, an additional associate career path that is not on track to be partner. And there was a lot of, controversy internally at Oric about this most recent stupid idea I had. Right? First of all, who would want this thing? And second of all, if they do want it, there's something wrong with them. They're not as smart as the rest of us. They're not as intense as the rest of us. No, actually, people like this a lot. They are just more human than the rest of us. They all know their children by their first names. They have ordinary lives, and you can't tell the difference if you come to Oric and you meet a set of lawyers, some of whom are career associates and some of whom are on track or are partners. You won't know the difference. There's no chance on earth you will know the difference because they're not different. They just chose a different job. This job gets to work on Instagram. When we sold Instagram to Facebook, career associates worked on that from Wheeling, West Virginia. That was pretty cool. And then they went home at 6 o'clock at night, most nights. And they have a different, there's no client development in career associate job. So it's a job a lot of people would want, but a lot of people wouldn't. And most of the people who hired on to be partners in a major law firm hired on to be partners in a major law firm because they have a set of expectations and career objectives and so on that they're looking for a certain kind of job. Anyway, okay. But I think there's a lot in medicine. Yeah. Yes, sir.
Other than 150 jobs that used to be in San Francisco, what does Wheeling, West Virginia have? Couldn't this be accomplished in California?
It could be accomplished in California. It could be accomplished in Manhattan. It could be accomplished anywhere. But not as, it needs to be accomplished in one place to do what we do there. So it needs the synergy of being in one place. And that's an important part of it. And the other thing is the cost of doing it there is way lower. The turnover is non-existent, but the cost is way lower. However much lower you think it is, it's lower than that. And the fidelity of the people to the jobs is on a different planet. So it just works better there. We searched all over the United States for a place to do it. You needed high work ethic, high reason to believe people would come to stay at the career and not turn over all the time. One of the challenges they're having in India now is they've reached a stage in their economic development that people now move from job to job because there are more and more jobs. And so we haven't reached that in West Virginia yet. But so yes, it could be done here. And some of the law firms that are creating centers are creating them in more expensive places. But that's not understanding the full concept. If you're going to do this, you should do it in a place that makes it the most efficient. So that means doing it better, doing it faster, doing it more reliably, all the positives, but doing it as inexpensively as you can. So, but yes, you could do it here. You could do it in the Transamerica Pyramid, where Oric was before we were in this building. So do you think we should?
I see you speaking in front of the Bar Association of San Francisco. I'm the Dean of the University of San Francisco School of Law, so I would hope that it gave a good deal of consideration about going from San Francisco to West Virginia.
Oh, absolutely. Well, why of all places? My goodness. It's one of the most beautiful states in the United States.
Beautiful state is also one of the most impoverished.
Well, it is. So this is win-win. So we save a lot of money. Everybody saves a lot of money. We build great careers. We do the work better. And a place that needed jobs got them. So San Francisco, I worked a lot on economic development in San Francisco. San Francisco has to be realistic. We're expensive as the dickens. New York City and San Francisco are really expensive. And if you think that we're going to have the same kinds of jobs in San Francisco with the housing costs being what they are and every other cost being what it is, well, you're not thinking thoroughly. You have to deal with what you've got. San Francisco has huge assets. Everybody wants to be here. It's great. But the cost of doing business here is much higher. That's a fact. And you can't ignore that. You don't expect the manufacturing to return and be up on Pacific Heights, do you? It's expensive here. That's a reality. Now, I will tell you what we did, since you asked the question. We recognized we were started here in San Francisco in 1863. So we care about San Francisco. So we did everything we could to minimize the impact on the people who were doing the jobs here and in New York, where most of them were, the two cities, that we could. And we only had 7 people in the end who didn't have something. They hadn't landed on something by the time all of the severance and everything ran out. So out of 70 people whose positions were changed. We offered everybody at firm expense the opportunity to move to Wheeling and keep their salaries at where they were, and so on. And a handful of people, including my assistant, accepted that, but most people didn't. But it's a serious issue. In fact, I'll get to why firms are slow to change. One of the really legitimate reasons that firms are slower to change than you might think is there's such disruption in the organization. So if you're going to change the model of law firms and the way I think law firms need to change, there's a lot of incumbents occupying positions you're not going to have. And that was the hardest question we had to deal with.
That actually goes to the question I was actually going to ask you, which is big law really the model for the future, right? If you're talking about more innovative kind of startup philosophy, are we
Mhm.
years ago.
Mhm.
But offering kind of these high-profile, high-end services that really are the end of the professional, the top of the professional justice pyramid. Is that going to be big law, or does that look different?
Well, it's going to look different. Let's turn to that. So what's the future going to look like? Let me start with this. There are two things I think will be at least as important, if not more important, in the future as they are now or ever were. And those are quality, results, what you deliver, and client relationships. So to be successful, certainly as a law firm or as a lawyer, you're going to still need to be A+ at this. In fact, even more A+ for the reasons we were talking about. But certainly as A+ at quality, meeting the client's expectations, and then client relationships. And then everything else is going to change, including the way law firms are structured. So big law. I think what's going to happen in big law, at least the following. There will be a shakeout. Because these changes, they're going to proceed at a pace that's not predictable, that is slower than you might think. But at some point, it'll pick up momentum, and then, as they say about the dinosaurs, there were dinosaurs until they weren't. And then suddenly, it'll be very different. It'll seem like it happened overnight, but it won't have. How many of you have read The Innovator's Dilemma by Clayton Christensen? So this would be something worth reading, because it goes to what's big law. So it talks about a set of examples of market-leading businesses who were threatened by innovation and by new entrants in markets, who were doing so well they regarded themselves as impervious to the competitive threat of these other businesses. I'm greatly simplifying this. Until one day they woke up and these innovators or these new entrants had eaten their lunch, and they were forever in a either gone or in a much lower position. U.S. Steel being the best example of that. And I think that's where big law is. We're making so much money, and we're doing so well. We've got all these important engagements, important client relationships, all of that. There's not an imperative to change, and then all these other things are happening around us that are going to change the landscape, and one day it's going to be too late. So there's going to be a shakeout. So there will be, I'm pretty certain, fewer law firms that we would consider to be big law. Part of that will happen by law firms failing. We've heard of that. And a lot of it will happen with law firms merging into other firms. And the way Bingham is doing apparently now with Morgan Lewis. Morgan Lewis has been pretty good at this with Brobeck and Bingham, and then and others. But there's going to be a shakeout, and there will be a consolidation as a consequence of that. So there's going to be big law, I'm pretty sure. There's some really interesting new data, and there are about 20 law firms, big law firms in the United States that, as of the data that just most recently has been published, are really pulling away from the others in their financial performance. There's a material difference, and that means probably that there's one market that those firms occupy, and they're pulling away both in profits per partner, which I don't believe is the right way to measure profits, but it's a way to do it, and revenue per lawyer. So they're just the engine of economic performance and the overall result of economic performance, the way the market measures it. These firms are pulling away. Now, so that's a significant fact of its own. But the other fact is what happens to everybody else. Because everybody else now, those people are likely getting more than their per capita share of the most important, the most high stakes engagements, both on the transaction and litigation side. So that means the other 130 or 180 of the AmLaw 200 firms are fighting for what is left. And there's more commodity in that. And there's more work that can be disaggregated in that. And so that's going to have its impact on the others. The other thing you can see, as I said before, is revenues flattening to declining, realization flattening to declining. Eric Press reported that if you adjust the economics for inflation, actually big law hasn't done so well, even over the years leading up to the Great Recession. So there's going to be some sort of shakeout, and there's a huge advantage in law to the smaller regional firms. I mean, there's research that shows that when you get an organization over about 50 people, it doesn't function as well as it did when it was smaller. That's one of the reasons law firms work pretty well when you divide it into parts and you give those parts a lot of independence to lead themselves and manage themselves. So I think smaller firms are likely to do better going forward than they have been doing because they can occupy a special place. But real change is going to come inside of the law firms. There are going to be fewer partners, for sure. In big law, there are lots of partners who made partner at a time when the world was different, and it was enough to really be a very good lawyer and a hard-working lawyer, and you justified being a partner. But in the world of today, with all this economic pressure, that won't be enough. You've got somehow to be a partner who really is driving the economics of the firm. Most likely someone who is that trusted advisor to clients, not necessarily that singular rainmaker, billing partner kind of idea that people have, but someone who is the personal relationship part that is causing that big client to continue to send you litigation or whatever it is. And so this is a really important distinction I'm drawing, by the way. That it's not just about rainmakers. In fact, rainmakers can be very dangerous to the culture of a firm. It's about people who, by virtue of their human, personal relationship with clients, cause the business of the firm to be stable and so on. But I think there'll be fewer partners, there'll be fewer on-track associates, and there'll be way more professionals who are neither of those things, and many of them won't be lawyers at all. And this back to this comparison to medicine, the model doesn't need to be the way that it is. The model is the way that it is because it was created at a time when law firms were small, and everything was different, and it just made sense. You hire a lawyer, and then that lawyer works out or not. Maybe you have a chance to make a partner, maybe you don't. But it's all about lawyers. And in the world of tomorrow, it won't be. It'll be about all kinds of other professionals, and it'll be about technology, and it'll be about collaborating with third parties who do what they do better, and faster and more reliably, and cheaper than we do it. I'll talk about some of those examples in a minute. But I'll give you an example of something that happened at Oryx. So we opened our center in West Virginia, and the other things we do there, we do everything else we do besides practice law is internal. So we do all of our word processing. We do all of, to the extent you still do that, but when we opened, we did a lot of word processing there. And we do all our financial accounting. We do all of our systems engineering, all the internal inward-looking stuff. Well, we realized that we could never get as good at word processing on our own as a company called Williams Lee is at it, because that's what they do for a living. So we subcontracted with them, and they now do our word processing in Wheeling, West Virginia. They also do word processing for 6 other AmLaw 100 law firms in Wheeling, West Virginia. They built a little cottage industry for themselves doing it in Wheeling, West Virginia. But we could never get as good as they were. Well, that's going to happen in law as well, where there will be elements of the delivery of legal service that law firms won't be able to do as well as some of the third parties. So I think that's one of the important changes, the shakeout of the big law and then the makeup of big law. And one of the reasons, one of the workforce, the talent model, one of the major reasons that the progress will be slower than it otherwise would be is that to change the model, to make it most economically efficient, will be very hard at a human level. Just as you were asking me the question about the people we had in San Francisco, if you realize that instead of having 1,000 lawyers, optimally you should have 600. There's going to be a lot of heartache to get from 1,000 to 600. And you're not going to do that overnight. Some are just plain not going to do it, but others are going to do it and hope that attrition takes care of it and so on. And it won't be as stark as 1,000 to 600, but it's going to be different. Fewer partners, fewer associates, and different kinds of people. So one of the biggest problems facing big law today is the number of partners in the firm who deserve to be made partner when they were made partner, but are not able today to keep up with what the firm's demands are. And so you see about all this de-equitizing of partners that happen in law firms, and partners are demoted to counsel and different kinds of categories because the law firms are struggling with the right way to handle, the human way to handle the challenge that they face. But the partners can't deliver what the market and the law firm's economics need them to deliver. All right, the other big change will be the role of these third parties. So third parties are going to enter doing a lot of different things. A lot of it will be the business of law, and I won't talk about that today, but there are a lot of new businesses being formed that do business of law kind of things, billing, collecting, all kinds of stuff. but a lot of them deliver legal service. So there's a category somewhere in the legal process outsourcing. How many of you have heard of Pangea 3 or United Lex? Same suspects. So these are legal process outsourcers. They will make an arrangement with a client. They really want to work with law firms as well as with clients, but the law firms aren't very welcoming to them, so they mainly work with clients. But they will take big parts of work that can be disaggregated, and they'll do it as a separate segment. And it's increasingly happening that big corporate clients are informing their law firms that you are going to work with United Lex, Pangea 3, or others in doing the work. There's another company that I've met recently called Novus Law. It's not quite a legal process outsourcer. They're a process manager, and there are going to be a lot of these. They come in and work with the law firm or with the client and change the way things are done. And they do a version of process mapping that we talked about with Seyfarth, and they've got this very objective data that show that they do what they do, which is mainly deal with complicated documents in connection with litigation or transactions, and touch them fewer times to get the outcome that is needed. The mapping makes the difference. And the outcome is not just they've reviewed the documents, but they've prepared all the witness files, they prepared stuff for trial, they prepared stuff for motions for summary judgment, and everything else, all in one fell swoop. And we're going to see more and more of that. And that's a marriage of process engineering and technology, because Novus Law, Pangea 3, United Lex cannot do what they do without modern technology that is this combination of hardware, software, learning, and so on. So that's one example of these new entrants that is going to change the way legal process works. Another, obviously, is legal research. How many of you have seen the work of Ravel Law? Was it cool? Yeah. Yeah. Which one? Daniel Lewis? Yeah. See, he was a law firm leader for him too. This just in New York, and he talked about his dad in telling the story of this business, and he's a really impressive young guy. So this is a young man who is 2 or 3 years out of law school, and he created this company and this research platform that does research, but it learns and it visualizes. And when I first met him, so this is the fun I'm having. So I get to meet these guys and see what they're doing. Well, what does that mean? Visualize it. I can visualize the cases too. They sit in a shelf and so on. But this, they do the research and they it's both research in law and in data, and then they portray it in a way that you can see what you're looking for in a way that's charted out, and you can find the meaning in the research that you need to get at. Only it's instead of taking you hours and hours and hours of lawyers coming through all of these cases and all the history of the cases, it's right there for you, and you can just go get it and make something of it. And back to this interchange we're having about what's the nature of the job you have as the trial lawyer, it's a better job. Because it's just like when you're a senior partner and you assign an associate, go find me a case that stands for this. I'm sure there is one. I don't know if you've done that, but I've done that before. And so that's all done for you in a way that you can understand, and it's fast. And then off you go, and you do the part you wanted to do. You now go to court and explain why it is, given all of this, that your client should win. So, and this is getting into the area of the use of this technology that seems to be thinking. It's because it's programmed to do that. Let me give you a couple of other examples. So, what's the best known firm in legal service in the world? Farella. Yeah. At your house. So what's the best known legal brand? Another way to put this. What's one you see on television all the time? LegalZoom. LegalZoom is the best known legal brand in the world. Right. So LegalZoom stands for something. Rocket Lawyer, which is a Bay Area business. LegalZoom started in L.A., and they don't practice law either. They deliver forms. In fact, if you listen to an ad or see an ad for LegalZoom, listen, and it will always say, we are not a law firm. And they're not. So they provide forms. They help people access the documentation they need. And then if you need a lawyer, they have a network of lawyers, and you can call a lawyer, and you can get practice of law if you need it. But they make available to people whose issues are not complicated, simple wills and so on. I mean, best suited for that sort of thing. They make that available. That they have. I just heard. I don't know if this is true. I heard that they are opening brick and mortar operations in Sam's Clubs, which is what's happened in England. So in England, after the Clementi report, these firms are being created, and they do have they do have stalls or something in retail establishments. So there will be more and more of that sort of thing. Legal staffing, Axiom. Everyone knows about Axiom, right? Providing lawyers so that your need, and so on. Now the high watermarks of this stuff, I think, are a couple of companies. One is called Practical Law. How many of you know about Practical Law? Huh? All of us?
Hopefully all of us are practical lawyers.
Well, no, but Practical Law is a business. It started as a magazine in London, and it did what it did, and it ended up being a compendium of all you need to know about certain areas of practice. Forms, substance, new developments, everything. If they had focused on that subject matter, you could rely on them as a very handy resource. And if you're an in-house lawyer and you've got to manage a bunch of different disciplines, these will be handled for you, and you can sort of refer to them. They came to the United States. They were bought by Thomson Reuters, and they've had some infusion of cash. And they now have 10 practice areas that go from antitrust to real estate, employment law, and they have assembled all of the resources, all the substance of the area in a practical way. So it's not just law in theory, it's law as applied with forms. And so if you're for litigation, all the different kinds of forms you might need. So it's knowledge management on a big scale, enabled by data. This wouldn't have been possible without technology, but with technology enabled, that really will take the place of a lot of lawyers who we all previously had to hire separately to do exactly the work that's already been done. And again, it doesn't practice law. It doesn't decide what the answer is for your client in your case, but it empowers you to know all you need to know before you do this. So big data. I'll tell you two more categories. Big data. How many of you in your day-to-day life are confronting big data or something that feels like big data, right? I mean, we all are here and there. The power of big data, when people assemble huge masses of data, the ability to distill lessons from that. I mean, that's how Google's following all of us, right? And all of that stuff is happening. So there are companies that are being formed to amass big data so that lessons can be drawn from it far more efficiently, more completely and more efficiently. So one is called one that I want to tell you about is Lex Machina. How many have heard of that? So IP lawyers have heard of Lex Machina. So Lex Machina, which started at Stanford, has collected up pretty much everything you could possibly want to know about all cases litigated since 1990 or something, some period of time. And it's everything. It's not just the cases, what they were about, but what judge did what in what motion. So that you can access Lex Machina if you've got a case in some district, in some state, somewhere that's an IP case. You can find out if every case your judge ever handled of that kind, and what she decided, he decided, and all sorts of stuff. It's very powerful. And these developments democratize the practice of law, because the advantage, if someone's an IP specialist, you do this all the time, you have a certain level of knowledge about practice and all those things you have. Now, you're a litigator who's never done one of these, but between practical law and Lex Machina, you can come up to speed really fast. But this big data is going to make a big difference. And then Watson is sort of the whole thing on steroids. Watson is both artificial intelligence and big data. So Watson has gone to law school, and it's done two things. It's digested huge amounts of case law and secondary sources so that it knows the answers to things, research questions. And this is what it did in medicine. The best story I know about this is in medicine, in which a doctor, to test the system, a doctor who had had a really nettlesome challenge with a cancer patient at Sloan Kettering, and had worked for years and years and years, and finally came up with a solution that saved the patient's life, but nearly lost it, and it had taken years. So, as part of the orientation of this new Watson in medicine, he presented what he had perceived in the patient to Watson, and in a matter of seconds, Watson had said, well, it's one of four things, and one of them was it, and which brought the doctor to tears, and so on. And that's the power of big data, that this doctor was able to access his own experience, the journals he could read, whatever it was he knew, and Watson can access it all. So what Watson is going to do is offer a service to law firms, lawyers, to help them manage their own data, access all the rest of the data that they've digested for you, and that's really democratizing, and then help you manage your own data. Some of the most powerful data that significant law firms have, I don't mean significant just big, but ones that have been in business a long time, done a lot of something, whatever it is, the work of Omaha or the work of some practice area, whatever it is, they have all this knowledge, but they can't get at it because they don't have effective knowledge management. And Watson is now built to help you extract that knowledge. So I think, anyway, all those companies I will think will be far more important. Here's a few other just quick observations. In-house departments are going to get much bigger. Just what John said, it's happening right now. John Schultz at HP is a great example of this. Not only are they bigger, they don't waste money on frills and so on, but it's going to be a big part of it because the needs of the companies are so much greater. So that means big companies get way big law departments. It means smaller companies get an in-house lawyer that they didn't have before, and a couple of people, because it's cheaper to do that than it is, especially when you have practical law and other things to help you, it's cheaper to do that than the alternative. Fees will become fixed fee arrangements. This idea of alternative fees, so alternative to what? Alternative to charging by the hour, that's just because that's how we ended up doing it. The billable hour is really not only not a good way to do it, it is bad for us. It makes all the incentives the wrong incentives. This is one of the things that being out of this for a couple of years has been helpful on. Think about this. When it comes time to compensate partners, associates, no matter what we say, we measure them on their productivity. We call productivity how many hours they devoted to the practice of law. That's not productivity. That's hours devoted to the practice of law. It may have produced nothing. We measure everything on inputs when we measure by billable hours. Clients measure what they do by outputs. And law is going to go to that. Law, it's inevitable. And the idea of alternative fees, let's do it a little bit of this and a little bit of that, there's not going to be a good model. What it's going to come to, I'm sure of this, is that we will charge in most circumstances on a flat fee basis, at least on a flat fee by elements of the work. So the thing is a big multi-year transaction or litigation, we'll charge by some subparts of it. We'll break it up into parts and we'll charge on a fixed fee for it. Big data will help us with this because big data will inform us as to what it does cost to do all this stuff, our own and everybody else's. If you combine big data from a lot of different law firms and a lot of different settings, you will be able to see that actually these things kind of all go alike. I experimented with this one time myself. I took 50 of my cases, and plotted them out. And 48 of them were within a pretty narrow band in what they cost and how they resolved. And 2 of them were outliers. And if I'd bid all 50 of them at the midpoint of the 48, we would have been fine. And we would have lost money on one and made money on another one. But because the 2 outliers were, one got resolved overnight and the other one we just lost our minds on and spent way too much time on. Right? But so the big data will help us. The market will expect it. And you'll see, I think, fixed fees, not alternate fees, fixed fees. Lawyer careers will be better, consistent with the discussion we've had. So people will end up in the jobs they really want, that pay what they need to be paid, what fit to what their aspirations are. They'll deliver value. And some people will make even more money than is being made today. Some people will do nothing but try the most important cases in the most challenging of circumstances, and other people will be doing things that that person would regard as boring. And there'll be a lot more jobs in these new companies that are created. And finally, legal education will be revamped. How many of you, when you went to law school, thought, they sure have this right. This is exactly how I should be trained? And I really wondered in my third year, what am I doing here? Well, I didn't think I got it. I think I'm ready. And I got much more specialized in a handful of subject matters, but really, I didn't think I needed that. That was just me back then. So now we're training people with a model that was designed for a way long time ago for a world that is not going to look anything like today. So legal education is going to be revamped. For the Law Firm Leader Forum this year, we had a bunch of academics. It made the whole thing better. It was really more fun. But two were deans, one from Georgetown, one from Ohio State, and they came and talked about the changes that they're making already in the way they train lawyers for the 21st century, and it's getting pretty different. And critical, of course, to legal education for the future is that it be much more practical, as we talked about, and that it be connected to technology. You can't prepare a young person to go out into the world now without preparing them to use technology as it changes. And of course, they come better prepared today anyway because they've grown up with technology. But it's a very important part of what the curriculum needs to be. So in closing, I will say that there are two important policy issues that we need to confront to me. One is the way we think about what is called this UPL question. So I learned in the last couple of years that the shorthand, UPL, unauthorized. Yeah.
Sending legal work across state lines to West Virginia. Are they practicing law in West Virginia? California licenses? Doing work for California?
Well, see, this is the kind of question we shouldn't be asking, in my opinion. But these our people are all authorized. They're licensed in West Virginia and elsewhere. They're licensed where they were before they joined us, and they're licensed in West Virginia. And they are practicing law in courts all over the United States. Actually, they may or may not get to court themselves, but the cases are in New York or California or someplace, and the transactions are too. So they're sitting there doing it there. So what state are they in, and what are they doing? So we just placed our bet on every number on the thing. So they're qualified in West Virginia, but they're really not practicing in West Virginia, and so on. But the thing I'm focused on is this. I think talking about the unauthorized practice of law, which comes up in the context of what we've been talking about, it comes up in connection with LegalZoom. So LegalZoom is being sued in different states for being engaged in the UPL, as though UPL is a crime, like it's murder, burglary. No, UPL is if anything, it's practicing law without a license. And really, I think we need to shift our focus to see that this, as I said before, what we're talking about is the delivery of legal service, like delivery of medicine. There's lots of people in medicine who are not licensed to practice medicine. But it's perfectly okay for them to be nurses and all this other stuff. So in law, we need, I think, to start thinking about it that way. We're in legal service. Some of us do work that requires a certain education and a license because we've been tested. And those are the people that advise clients, given your facts and my knowledge of the law, you should do this. Or the answer is that. That's the practice of law. The person who stands up in court as the lawyer on Jones versus Smith and says, Your Honor, my client's innocent, that's the practice of law. You know it when you see it. And then there's lots of stuff that's not the practice of law. And I think if we had a more open mind, this would go better, and these companies that want to become part of the legal system would be able to do it. The other is public investment. We've got to let investors invest in law, not so that they would make the partners in a law firm rich by going public. That's not going to happen. But because the capital that's necessary to create law firms that can make the most of what we've talked about today in the corporate setting, but even more so in the setting of the individual citizen, to make that possible, you need some capital. You can't do it otherwise. The person who is going to end up doing the will for the 50-year-old couple that is just struggling to get by has got a business model that's almost impossible to work. That person's in charge of sales, person's in charge of production, in charge of everything, and they're going to be more expensive than they need to be. So if you created companies if you enabled companies to have investors and create a company that would deliver legal service, you can maintain the standards, you can articulate the standards, you can measure it, and England's doing it, Australia's doing it, and we should do it in the United States. It would be better for the clients as well as everybody else. But the myth that this is somehow going to make people into Goldman Sachs partners going public on the New York Stock Exchange is just not right. So that was intended to provoke some discussion. Do we have about 5 minutes? Yes.
So do you think the ethical rule prohibiting partnerships with non-lawyers will change as a result of the trends that you just identified?
Well, I hope so. I think it will it will change if the large law firms that compete with American lawyers, the large English firms that compete with American lawyers, start taking money, accepting investors. And that's what's going to happen. This will not be going public. It'll be accepting investment. So you've got some capital that is not after-tax income of your partners, which is the only capital. The current rules permit a law firm to raise capital either by keeping after-tax money from the partners. So you earn $100 and you give $40 to the government and you give $100 to your firm when you deposit capital. That's the model. Or you borrow it. And with Brobeck Dewey, it didn't turn out so hot to borrow a lot of money. So, but that's the only way you can access capital. So the model I'm talking about would permit the English firms to accept investment, not majority investment, not publicly traded, from outsiders for which they would get a return. And that's what we're talking about. And I think what will happen in England is eventually firms will take money, will accept investors, they will benefit from it, and that will enable them to compete more effectively with the American firms, and then the rules will change. But in England, the way it changed was it was looking after the ordinary citizen. That's what Clementi was about, delivering legal service to the moms and pops. Yes.
The news lately has been that especially big firms are thriving on transactional work that litigation is down. How do you see that happening? Is that a trend or just a temporary condition?
I think it is A, true, and B, I think it is a trend, but we won't know. We're just not going to know. We're living in a time, of evolution that when 20 years from now we'll look back and understand why it went the way it went, but we don't know how it's going to go. But I'll bet it's a trend. I'll bet that is the clearest example of the work going elsewhere. That millions and millions of dollars of what would have been work done in the law firms is being done by United Lex, Pangea 3, Novus Law, and similar. Lots of it's being kept in-house. These big law departments are building law departments of people who are highly experienced, and they can do a lot of the work. They could try the cases, but they can do a lot of the work and going elsewhere. So I think that's what's at work. But we'll see. Yes?
There's sort of two or three trends that you pointed out that seem to have some long-term consequences for the practice of law. One is that sort of what it means to be a lawyer may go a little bit more high level, right? That folks like John will be sort of making these judgment calls, but computers like Watson or these other systems you've mentioned perhaps will even replace many fourth-year associates. And then you also have this expansion of sort of other legal sector jobs that aren't lawyers, paralegals, perhaps. I wonder if the way to get there, or a key part of getting there, will be a shift among the law schools to graduating fewer, smarter sort of lawyers, and then perhaps increasing the number of other degrees they offer. Either for, my law school didn't have a paralegal degree, but perhaps it should have. Perhaps other law schools should have. Perhaps there are other law technology degrees should come out of the law schools. Is that a direction you see anyone going or thinking about going? Is that something they should be thinking about? What do you think is going to happen other than sort of the law school model changing in some way or another, getting to the third year?
Yeah, I think it's inevitable that it will go kind of like you just described it, in the sense that people will be trained for these other jobs. Somehow that'll happen. Now, maybe it happens in the design school. Maybe it happens in in computer science or someplace. But in the end, schools, which are trade schools, law school is a trade school of a kind. We're training for a profession, but you're learning to do something. Well, so the curriculum has to follow what it is you're preparing people to do. So it just seems it's got to go there. And my sense from talking to deans is that they're being very thoughtful. Although I think that in some schools, like law firms, are doing so well that they don't have the same imperative to worry about it that other schools do. But again, I don't know how that's going to play. I don't have any data that tells me how it's going to play out, but it must kind of go the way that you're suggesting. The law schools are in a world of hurt right now because there's so much controversy about how much it costs to prepare for a profession in which it's so hard to earn enough money to justify what you spent. And so that's an element of pressure that they have, in addition to wanting to prepare their students for the world of tomorrow. They're being criticized for how expensive they are. And it's not an easy task for them to become less expensive, but it's a real challenge that they have. Yes?
So I will ask the Bar Association of San Francisco question, which is, with all these changes in the future for law firms, for individual practicing lawyers, do you have any thoughts about what a Bar Association offers to members, to law firms, what strategic advantages a Bar Association can provide in the community to make the practice of law either more rewarding for its membership or more financially profitable, or all of those things that I could
Well, I think a bar association like San Francisco is a perfect place to enable people to talk with each other in a non-threatening setting about what's happening. And while you didn't pay the electric bill, in a non-threatening
They
setting.
cut you off here because they thought you were going to say
Yeah.
something that was.
But so we're all facing these challenges. And sometimes the way they're working, you don't really want to admit it, that you're out of touch with somebody, you lost this client or something else. And when we're all colleagues, we live in the same place, to be able to talk with each other about the changes and best practices, I think would be pretty helpful. We all need to think about these policy questions, whether they're the two that I identified today or others, and work together to proceed toward better rules if the rules are a problem. Well, our time is up. Thank you so much for having me.